all confidence.
If you get a chance, you may want to put another throw rug on underneath your feet because the mic is really still a little echoey.
Oh, really?
And I know it's not the mic.
Okay.
Just a thought. We can get you a brand new ESPN Sports headset. They're only $22,000 a piece.
When I go national.
Well, I asked him, is there any way possible that I could get like 2 of those? And they told me how much they were. I'm going, oh God, no way.
WPTV's First Alert Weather on WPSL is brought to you by Seacoast Air Conditioning. Family owned and operated on the Treasure Coast since 1982. Online at seacoastair.com. Now with a look at our forecast, here's meteorologist Katya Hall.
Your WPTV First Alert forecast: increasing clouds this evening ahead of a strong cold front. This front could push in some stray showers throughout the night. Tomorrow, some clouds to start, then quick sunshine through the afternoon. Morning temperatures down in the mid to upper 40s and afternoon highs in the mid to upper 50s. Sunny and windy throughout the day. Sunday, morning temperatures are down to the 20s and low 30s. Afternoon highs in the 50s with plenty of sunshine. I'm WPTV First Alert meteorologist Katya Hall for WPSL 1590, the talk of the Treasure Coast.
The nationally ranked IRSC men tip Wednesday at 7 at home against the Manatees. Saturday at Florida Southwestern at 2 on WPSL Global. The Heat are at home all week. Wednesday with the Knicks, Friday against the Clippers, and Saturday versus Toronto on WSTU. 2022 IRSC Heat Magic are brought to you by Indian River State College Athletic Department and Tojitos Mexican Restaurant in Fort Pierce, Nice Air, Hoskins, Turkle, Lloyd & Lloyd, St. Lucie Draft House, Seacoast Air Conditioning, Florida Blue, Max Stuckey, Stuart Elder Law Attorney, Stimmels of Stewart, South Florida Orthopedics.
If you own a business, is it protected? Are you protected from personal liability for lawsuits against your business? Are you protected from employees who quit or are terminated? Are you protected against wage and overtime claims? Hello, I'm attorney Stuart M. Address. I've been practicing law for over 30 years. If you have employees, use purchase orders, invoices, or contracts, or have a customer list or trade secrets, then you may need to make sure that you are protected. I believe in aggressive advocacy combined with personal attention for each of my clients. I care about each of them. For a review of your business documents or to create necessary documents, call me at Stuart M. Address, PA, 772-781-8003, or send us a message through our website at www.stuartaddresslaw.com. Our office is in Stuart, Florida.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. I am Stuart Address, and this is Ask a Lawyer. It's January 28th, 2022. And though I don't know, 2 years, 10 months of the pandemic, should we start having a, coronavirus pandemic after the year? Hope it's not
Pandemic
gonna last
party.
long enough. What was that?
Pandemic party.
Yeah, party, that's right. Party that's preventing me from doing lots of things, and some other people as well, although there are certain people who feel free to walk around the cabin. Anyway, this is actually the last show of year 4. I found that out on Facebook.
How about that? Cool.
That's right. As we begin February, it is the beginning of year 5 of Ask a Lawyer.
Well, and you look at it this way. I mean, that's just a quarter of a way through your 20-year contract.
Oh my God, you're not going to hold me to that, are you?
We're tying it to you.
And folks, for anybody who cares, yesterday was my 1-month anniversary, or as we like to say, my 1-month monoversary.
No comment.
It's actually been an entire month since this Michigas. And the bills remain.
Oh, you're such a
Oh, I think I just heard some noise coming from far back in the house. That must be my wife.
Yeah. You're just such a romantic dude.
Oh, I really am. You better believe it. All right, folks. Let me ask you all a question. It's rhetorical, by the way. When is the last time you heard about the Equal Rights Amendment? You know, that amendment to the Constitution that would make very clear once and for all that women have equal rights to men. When's the last time any of you heard of it? Did you know that it was supposed to go into effect 2 weeks ago on January 15th? That would have been 2 years since Virginia became the 38th state to pass the ERA, which implicated a 2-year waiting period for the amendment to go into effect.
Wait a minute. Time out here. What?
Time out on the field.
What?
What?
They've had equal rights at the polls for years.
Equal rights to vote. There's also this thing called the Equal Pay Act, which is not really enforced very well. There's also Title VII of the Civil Rights Act, which would give women equal protection in employment. But what about elsewhere?
Okay, I just would have assumed that they would automatically have that.
Well, Greg, you know what happens when you assume.
Yes, I know. I know.
You make a fool out of you and me.
Wow. Okay.
Now, the Equal Rights Amendment was intended to be an amendment to the Constitution, which would ensure that women had equal protections under the law to men. Now, remember, when we first were colonies, in fact, when we first had our Constitution, I think blacks were 3/8 of a person or something like that. Women didn't count. The only people who really counted were people who owned land. Those were the ones who could vote. This is how we started. And yes, the women got the right to vote a bit late, but they had it and they've exercised it. But they don't have, at least under the Constitution, they do not have equal rights. So this was an amendment that was conceived nearly a century ago.
But common sense tells you they do.
But the law says they don't.
Oh, brother.
Hey, what can I tell you? It wasn't until 1972 that Congress finally passed the ERA, allowing the states to vote on ratification of the amendment one by one. That is the process set forth in the Constitution for amending it. Okay, Congress has to pass an amendment. The states then get to vote one by one. You need 38 states, which is 3/4, to amend our Constitution. It is supposed to be that difficult. So, even though it took 50 years to get to 38 states, Virginia became the 38th state on January 15th, 2020. That meant that based upon the preamble to the ERA that was passed by Congress, it would take effect in 2 years, January 15th, 2022. Now, the ERA is a very simple amendment. It's very short and sweet. It says equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. That's all it says.
Sounds pretty basic to me.
Pretty basic. And so you have a constitutional amendment you can enforce in the event of any form of discrimination, pay, employment, voting, anything, medical procedures, anything you can think of.
But why is it that women get maybe at best 3/4 what a guy would get for the same job?
Well, because it starts from I'll say the discrimination that first existed when women really started to work, when we started to have 2 wage earner families, which was really in the 1970s when inflation went crazy and people needed extra income. And so all of a sudden, including my mother, all of a sudden you started having women enter the workforce in droves. But they did not have the protection of equal pay. And the stories I have heard, I have no firsthand experience, but the stories I have heard many times is that you had chauvinistic men whose attitude was, you don't deserve to get paid as much as a man. This is a man's career. You're just working here, for extra money. Or you're a homemaker. You should be lucky I'm giving you a job. And so there were improvements over time. It takes a long time. And I don't know if I can call it fair. I certainly can't call it fair. It is improved, but you're right. Women earn about 73 cents on the dollar to men. And the Equal Pay Act, although it is a statute, has really not been enforced very well. And would a constitutional amendment make it more viable? Most probably, yes. All right. When we sue in employment under Title VII of the Civil Rights Act, we're not really suing just under a statute. We're suing under the 14th Amendment to the Constitution, which provides for due process and equal protection. So, and that gives rise to another question. Well, if we have the 14th Amendment, which provides for equal protection under the laws, isn't that The ERA?
One would think.
Well, I think one could make that argument. But the history behind the 14th Amendment was to provide equal protection to African Americans and minorities. And is it clear that women can take advantage of it in that way? Not so much. So an ERA amendment would make it clear and unequivocal. And that's what the goal was. So it would only have been the second mention of women's rights in the Constitution. The first one is what we now call the 19th Amendment, which gave women the right to vote in 1920. Take a long time, we're talking 102 years since women got the right to vote, and we're still arguing over, is the ERA now a part of the Constitution or not? And ultimately, that's going to be for the Supreme Court to decide. Why? Because the Trump administration, anticipating that this amendment was going to go into effect January 15th of 2022, in 2020, he had his Department of Justice prepare a memo. And that memo had to do with whether or not the passage of the Equal Rights Amendment by Virginia as the 38th state meant anything at all, because a time limit was in the preface to the amendment, not actually the amendment, but the bill that created the amendment that would take effect. So the memo read in part, quote, "We conclude that the ERA resolution has expired and is no longer pending before the states. Therefore," what President Trump said, "you have to start this all over again with state number 1. Well, it took us 50 years to get to state 38. That is not exactly the way the Democrats wanted it to work out. The memo that the Trump Department of Justice prepared continued, quote, "Even if one or more state legislatures were to ratify the 1972 proposal, that action would not complete the ratification of the amendment, and the ERA's adoption could not be certified under Title I of the US Code." So, under instruction from the Trump administration, with the authority of this Department of Justice memo behind it, Trump administration instructed the National Archives and Records Administration not to publish the ERA in the Constitution. If it's not published by National Archives, then it's not in there.
So why haven't we heard a thing about this?
Well, it may not have reached public consciousness right now, especially with everything else going on, but it is being litigated. So what happened is, when Biden took over, they took action on this. Now, first of all, before Biden ever did anything, the House of Representatives did something. January 21st, 2021, about a year before the amendment would take effect, knowing of the Trump administration's instruction to the National Archives and knowing of the Department of Justice memo, several congressmen introduced a House resolution urging Congress to acknowledge that the ratification of the Equal Rights Amendment was valid. The proposed resolution read in part, quote, "It is the sense of the House of Representatives that the article of amendment to the Constitution relating to the equality of rights, commonly known as the Equal Rights Amendment, duly proposed by 2/3 of each House of the Congress and ratified by more than 3/4 of the several states, has met the requirements of the Constitution and become valid to all intents and purposes as a part of the Constitution and shall be known as the 28th Amendment of the Constitution. That resolution was passed in the House. Guess where it is now? In the Senate. What happens in the Senate these days? Things go to die.
Yeah, not a damn thing is going to happen in the Senate.
That's right. It is stalled in the Senate with no prospects for being brought before committee or being voted upon by the entire Senate. And of course,
I still don't understand, why does that body even exist?
the Senate,
Yeah, they're useless.
oh my goodness. You know, let me tell you, when I was growing up, the Senate was the august body, the senior body of the House, of the Congress, that was more deliberate, more considered in their approach, more friendly across the aisle, Republican and Democrat. And while the House may shift wildly from time to time because of election every 2 years, the Senate, serving for 6 years at a time, did not so much have to worry about something that happened in month 3 of the 2-year term. The Senate, if somebody voted in a way that was going to upset their constituents, they had time, excuse me, to rebuild that trust and faith of their constituents and put aside maybe this 1 or 2 votes that their constituents didn't like, and not worry too much about reelection, because incumbents are reelected about 2/3 of the time. When I grew up, the Senate was very well respected. It was the House that, as was intended, being the people's house, was more argumentative, more striking. And so statutes went to the Senate to be duly considered and debated upon, and not for the immediacy of some popular opinion to take effect. Now, of course, I would agree with you, it's worthless. We do have a caller. We have John on line 1. So let's take that call.
Yes, good morning.
Hi, John. How are you?
All pretty good. I have a question for you. If a business is a nonprofit organization, is their business public? Can they hide a purchase or, you know, whatever?
Well, is it public? It's not public in the sense of being a public company. It is more public than a regular private corporation in that, to gain its tax benefits under Section 501c3 of the Internal Revenue Act, they do have to make certain information available generally to the public and to the government. Anything they make available to the government, the public has a right to under the Freedom of Information Act. Beyond that,
let me narrow that down.
Sure.
Without pointing a finger, but say this organization got a grant and they're doing some renovation or, you know, whichever way they choose to use the money, and a contract goes out for bid, but they won't tell the bidders what they got, how much the bid was that they gave to an individual. Does that make any sense to you?
it does. You're saying they give the contract to one of the bidders, but they're not making available what the bid was, so you know whether or not you were the lower bidder or was that the lower bidder.
Yes, it was too low. I mean, if I was lower or higher or,
There's no statutory provision I know that requires that information to be given to a competing bidder. Now, could that bidder file a legal action if they believe and have evidence that there is some actual fraud? I think so. And if there is enough factual indicia for a judge to say, well, the suit's not going to be dismissed, then they would have the right to discover it. But absent that, I don't believe they have to provide that information.
I know there was favoritism because the bidder who got the job was a close friend of the treasurer of the business. And they just refused to disclose what this person's bid was over the others,
Was this like an HOA or something?
No,
No, because as I was going to say, under an HOA, you would certainly have rights if you suspected that, because the directors would have a fiduciary duty to protect the assets of the HOA. What kind of a business are you talking about?
it's the arts,
Okay, so you like an arts council or something like that.
what?
Is it part of a, it's just like it's a chicken or an egg or 20 questions. Is it part of a state or local government?
Is it sponsored by a local government?
Well,
It was started by one person. It's got a board of directors. It's got a president. It's more entertainment than anything.
then I would have to say from the information I have that probably not.
Okay, all right. Okay.
Good questions, John.
Pardon me?
Good questions.
Well, thank you. But listen, thank you for your information. I always enjoy listening to
You're
you.
very welcome.
Take care, stay healthy.
Bye-bye. You too. Well, those were good questions.
Aren't most bids sealed though, and stuff like that?
Well, they're sealed, but depending upon what the bid package provides, either in some instances, all the bids are made public so that you can tell whether the lowest bidder got the job. It doesn't also mean the lowest bidder has to get the job. You could have the next lowest bidder that you think is a much more reputable, reliable company. It's been around a lot longer. And that if, let's say it was an HOA, let's say somebody in the HOA sued that you are not exercising your fiduciary duty to protect the assets of the company, of the corporation, of the HOA. Your response would be, yes, I am. Just because I agreed to pay, just because we as a board agreed to pay an extra $12,000 for this project doesn't mean we're not fulfilling our duties. We happen to think that this company that gave the lowest bid doesn't have the capacity or may not be around a year from now. So we gave it to the second lowest bidder. That's a perfectly legal analysis by a board of directors. But there has to be a reason. And if it's just because I gave it to my friend, then you are violating your breach of fiduciary duty to the rest of the homeowners. So, another topic we might be able to cover one time. It's the obligations of that. And just because somebody becomes a director, being a director is an important thing, even though it seems like it's not. Because once you become director, you have a fiduciary duty to that company. You can't just call in your vote. You have to participate, understand, and vote based upon your analysis. And if you don't do that, you're breaching your fiduciary duty and can be held responsible and accountable. So, it's not like, well, you hear, oh, this person just got appointed to this big board of directors. Well, yeah, they did, but they've agreed to accept certain responsibilities for that lovely privilege. Anyway, going back to our topic, the Biden administration followed the House's action about 2 months later, on March 17th of 2021. It asked its Office of Legal Counsel, the White House Office of Legal Counsel, for a new opinion. And the new memo did not withdraw the Trump's memo, but it did provide that the issue was more complicated than the Trump era opinion stated. And the new Office of Legal Counsel memo effectively deferred the issue to Congress and the courts, adding that the 2020 opinion of the Trump administration, quote, is not an obstacle either to Congress's ability to act with respect to ratification of the ERA or to judicial consideration of the pertinent questions, end quote. So Biden's OLC didn't come out and say, oh yes, everything was proper and the ERA should become part of the Constitution. It came back and said, really, what the only thing that could happen is Congress had to either decide this, okay, it's stalled in the Senate, so that's not going to happen, or it goes through the courts. And so, in many states, legal actions were filed in federal court. They are just now, this is now, a year ago, they are just now beginning to percolate into decisions in the lower district courts and then going up to the Court of Appeals. And since I anticipate there will be conflicting decisions in the federal circuits, I hate to say based upon who the judges are, because I grew up and I became a lawyer believing that every judge did their solemn duty in analyzing the facts of the case and not prejudging it. But I am unfortunately now equally jaded that it does not appear that that is true.
My
And
goodness,
that's
were
very
you
likely if
gullible?
you have the right judge, you have a better chance of getting the outcome you desire.
You were gullible as a kid.
Well, I guess I was idealistic,
Yeah, I get it. No,
I recall the night before I began law school, I went two places. I went to the Lincoln Memorial, because I was in DC, and I sat there and I looked up at that giant statue. I didn't know I was going to be going into civil rights law and discrimination at that time, but I looked up at that bastion of equality. And then, since it was much closer to where I was living, I sat on the steps of the Supreme Court and looked up at that building, not imagining when I would argue before the Supreme Court. I never have, I never will. I am a member of the bar of the Supreme Court. So I have the right to go in there and sit there for an entire case instead of being a member of the public and shuttled in and out every 15 minutes so that more people can see arguments.
aren't you even fascinated about arguing before those guys and ladies?
Yeah, there was a time in my career where I was fascinated. There was a time in my career where there were a couple opportunities where it might even have happened if a case went a certain way, because then I knew the other side that was more powerful and bigger was going to appeal if it won. So there were some chances. None of them ever came to fruition, but I did sit there before law school began, and I was idealistic, and I thought about what I was about to embark upon. And we're now, gosh, geez, we're 40 years later, literally. I sat on those steps in August of 1982. We're now in 2022, 40 years ago. It's hard to believe all that time has passed. It really is. But like the ERA, I'm still kicking. And it is going to ultimately be decided by the courts. Now, what is the history of the ERA? Well, the history is really rather fascinating. But if at any time you feel it's dry and boring, you can call 340-1590 and ask your own question. Or just tell me it's dry and boring, move on. I'll take either one. The ERA was first proposed in December of 1923. It was promoted by the National Women's Party. And it was opposed by many of their colleagues who had worked to pass the 19th Amendment, the women's right to vote, in 1920. The attitude was, we gave you the right to vote. What more do you want? Literally, that was the attitude.
Are you serious?
Right now, there would probably be a line in there. We gave you the right to vote. What more do you want?
Oh, brother.
The ERA would have eliminated protective legislation, which for years reformers had sought for female industrial workers. The National Women's Party was determined, though, that women should be treated as individuals under the law, just as men were, not as a class that was subject to mass governmental regulation. So, even though the ERA would have undone some benefits that women had received, particularly as workers in the manufacturing industry, the attitude was, we don't want to get protections here, there, and there. We want one thing that says we're equal to men. And that's been the argument effectively for 50 years. You know, this is what we want. Why do you need it? I haven't really heard of substantive arguments as to why it would hurt us, why we shouldn't have it. I've heard, why do you need it? I've heard you don't need it. But if that's the case, why not just give it? I won't say to women, but why not just give it to all of us? Have it very clear. So it wasn't until 1972, look at that, 50 years later, that a version of the Equal Rights Amendment was passed by the House and the Senate and finally sent to each state for ratification. The legacy at that point of the 1960s civil rights movement seemed all but to assure passage of the ERA. However, only 22 states ratified it in the first year. Most of them had already resolved in their own state constitutions that women were equal. But with a revolution comes what? Counter-revolution. And by 1977, only 13 additional states had ratified it, making for what? 35. Yeah. And there was an extension of time that Congress gave. It passed an act that gave an extension of time for passage of the ERA for 38 states until June 10th of 1982. Another 5 years. But the proponents of the ERA could not get the necessary 38 states by 1982. National polls at that time showed that the majority of Americans were in favor of the amendment. Opponents, who ranged from the John Birch Society and Phyllis Schlafly's Stop ERA movement, to conservatives throughout the political spectrum, Protestant, Catholic, Mormon, Jew, combined successfully to defeat the amendment. So Virginia, who had rejected the ERA a few years earlier, comes under control of Democrats. And in 2020 passes the constitutional amendment, becoming the 38th state to pass the ERA. So if there was a time limit, and if Congress extended it, and if Congress didn't extend it again, then why does this matter? It's irrelevant. On the other hand, did Congress have the authority to give a time limit in the first place? There's nothing in the Constitution that provides for a time limit. There's nothing in any statute that provides for a time limit. The time limit isn't even in the amendment. It's in what's called the preamble, the introductory section. So you have litigation. And there are some arguments that are made for the amendment legally that are very interesting. Experts and scholars point to a variety of reasons that the 2020 memo should be thrown out, including that Article 5 of the Constitution does not mention anything about deadlines. It provides that the Constitution shall be amended from time to time by 3/4 of the states. Doesn't say within 10 years, 5 years, 3 years, an extended amount of years. It just says by the states. So we have a constitutional argument there. Now, we also have some practical arguments. The 27th Amendment, which prohibits laws that change a congressional lawmaker's salary right before an election, was added to the Constitution, wait for this, wait for this, wait a little longer for this, 200 years after it was first proposed. 200 years after it was first proposed. And it is the 27th Amendment to our Constitution.
Welcome to DC.
That's right. Now, in response to Republican criticism that 5 states had rescinded their ERA ratification in the last decade, experts and scholars point out that the 14th Amendment, due process, equal protection, these major fundamental constitutional rights that we rely upon, the 14th Amendment was passed even though 2 states had attempted to rescind their ratifications. In other words, you can't rescind a ratification. Once you have ratified it, you have fulfilled the constitutional duty, and it's there. Now, if you have rejected it, like Virginia did, and later ratify it, well, your rejection had no constitutional implications. It's only the ratification that has constitutional implications. And so that's why.
What did Florida do?
Florida, honestly, I don't know. I don't know when if Florida's ratified it, when it ratified it. I did not look that up. You catch me with my pants down. And that's not a pretty sight. Now, so I would contend, and many have, that Republicans cannot have it both ways. You cannot count amendments when you want them to count and say they don't count when you don't want them to count. The Democratic lawmakers that passed this resolution in 2021, among various things, said, quote, after generations of fighting for the ERA, sex equality deserves a permanent home in the Constitution. A flawed opinion of the Office of Legal Counsel must not be allowed to stand in the way of their rights, they wrote in a letter to the Attorney General. They continued, it is long past time to bring the United States Constitution into the 20th, let alone the 21st century, by expressly recognizing the equality on the basis of sex. What happens then? Well, it's a very nice letter to the Attorney General. The Attorney General doesn't have a thing to do about this, honestly. I mean, could the government, the federal government, under the authority of the executive, Biden, file its own lawsuit to have declared the Constitution in effect? I guess they could, and to that extent, the Attorney General and the Department of Justice does have a role. I was too quick to say they don't. But the fight is already being fought in the states. And this is one area where I happen to agree, states' rights. Why do I agree in states' rights this time? Because it's actually in the Constitution. The Constitution says the states shall ratify, and when a sufficient number have ratified, then it becomes part of the federal Constitution. So it is up to the states to litigate whether or not the 38 votes should be counted, or whether the 38th vote came too late. And that's being done. So since Congress refuses to make a decision, really the Senate, it goes the only other place it can go, to the courts. Now, what do I think would happen if it got to the Supreme Court with a 6-3 conservative majority, and anticipating that whomever President Biden appoints to take Justice Breyer's seat as he retires at the end of the term is going to be maybe not as liberal as Justice Breyer, but pretty liberal, and is going to vote with that block of the court to keep it 6-3 in essence. Do I think it's just going to be voted that way? I don't, because this is not a Republican or Democratic issue. I mean, abortion, the parties have taken sides. Many major issues, the parties have taken sides. Even masking and getting the vaccine, the parties have taken sides. But the ERA, I don't think the courts will view that as Democratic or Republican. I would hope that that's going to be viewed as a constitutional issue, and that they're going to look at, as the conservative justices always say, let's look at the language of the Constitution. And the language does not have a deadline. So I would hope that would result with eventually in a year or so in passage of the 38th of the 28th Amendment, acceptance of the 38th state passing it, and that it would then be written by the National Archives into the Constitution and codified in the US Code. So, noting that we have about 10 minutes or so left, let me run through what I think are some of the 10 pros in favor of this. Number one, if Congress has the right to set a deadline, it can overrule it. Two, The amendment would offer equal rights to both genders. Every person identifying as a male or female in the U.S. would receive the guaranteed legal rights and protections of the Constitution. That means all civil, all human, all diplomatic rights would be included with passage. Now, this process would provide clarification to court rulings that are related to discrimination based upon gender, allow for the creation of protective laws, and make it possible for most people to do something about discrimination against them if they encounter it at home, in public, or while they are at work. Now, I'll give a great example here. Well, nah, it's not so great of an example. Well, I don't know. Maybe it is, maybe it isn't. I'm just going to tell it to you. I had a prospective client, I think I may have mentioned this once before on the air, who was on an airline and was forced to, told to take his mask off. It said, F, you know what, Trump. No, it said, F, you know what, Biden, you know, and something favorable about Trump. And one of the flight attendants asked that you remove it. He said, no. The plane had not yet left the gates, and law enforcement came on to escort him off. That particular airline refused to let him fly with that face mask. And when I got deep into the police reports, because I was considering the case, I saw that the officers agreed that he had done nothing wrong, that nobody, even the passengers, objected, only that one flight attendant. So the police officers then went to talk to the pilot. The pilot said he agrees it's not a problem, but he has to support his flight attendant. Now, why did he really have to? Why couldn't he have been a man, the pilot, and made a decision? Well, we all know why. The union would have been all over him. The flight attendants union would now be angry at the pilots union, and it would have been a mess. So he did the easy thing. I have to support my flight attendant. So they wouldn't let the guy fly. That airline let the guy fly the next morning. No incidents on the plane with his mask. It was that one person. Now, could he have argued, if this amendment was in effect, that he was being discriminated on account of sex? I don't think so. I don't think that would be a strong argument. If there was two people with similarly negative face masks, although not exactly identical, and only he was asked to leave, not the woman, could he have argued that? I think so. But not right now. Only if this amendment was available, because the airliner is not considered a public place under law, unlike the airport, which is. If they had told him to remove his mask in the airport would be sued right now. And I'd be happily representing that case.
It can't
The
get
airline
it can't
is
get
not a
much
public
more
place.
public.
What?
I mean, the public flies on it.
Well, that's what I thought. But when I looked at the court opinions, it is owned by the airline. It's a private corporation. Now, I think that's a stupid analysis, because restaurants are owned by private people, but restaurants are considered places of public accommodation. A restaurant that refuses to serve a man or a woman or a Haitian or a Puerto Rican or anything is going to get sued under, 14th Amendment. So, not all opinions make sense. And here's an illustration of where maybe it might have impacted it. Third, the Equal Rights Amendment would eliminate laws that do discriminate against gender, and maybe make stronger the Equal Pay Act. Fourth, it could help with future corporate recruitment needs, because the evidence has showed in human resource studies that when women know they're going to be treated equally, more qualified applicants apply. That means really pay. The ERA could help with an improved reputation in the world. You know, lately the U.S. Isn't looking really great in a lot of respects. This is one of them. We don't have anything that makes it clear that men and women are equal. It could help to enshrine into law transgender, non-binary, and other gender identification rights into the Constitution. Just think of it. The proposed amendment doesn't say gender. It says on account of sex. Transgender people make the distinction that this is not a gender issue. This is a sex issue. And I don't mean sex as a fornication. Okay, there's another definition of sex. It could just eliminate discrimination in funding for specific medical services. Like, you know, this is not a medical service, but we all know that women pay more money at the dry cleaners than do men. That might be illegal if this amendment were passed into law. So, you know, I just thought as we run out of time that Greg is right. The Equal Rights Amendment has not been in the public consciousness for quite some time. And I thought it might surprise some of you, it did me, to know that 2 weeks ago it was supposed to become the 28th Amendment. And that is now embroiled in litigation. So we'll have to stay tuned and see what happens. So until next Friday, on this same station, at this same time, we will have to wait for the next episode of Ask a Lawyer. This is Stuart Address saying goodbye. Have a great weekend and a great week.
WPSL Port St. Lucie, WSTU Stuart.
This is CBS News on the Hour, your home for original reporting.
I'm Steve Kathan. Scary scene in Pittsburgh. A two-lane bridge collapsed early this morning. A human chain was used to rescue some people.
Bridge collapse.
Size
Bus
it
went
up.
over. So far, I think
They're
we have
not.
3 that were injured.
Mayor Ed Gainey says injuries have been minor,
Have a good
no
weekend.
fatalities.
Talk
Drones
to
have
some
been
of you
used to make
soon.
sure no one's trapped.
Yes, I
That
know you
bridge
left
is a few
Montreal
miles from where President Biden will
1960
visit today to
1958.
tout his legislation
Making
designed to fix up
$45 a
bridges
week.
and roads.
With him
Came
coming
to the
today
US,
to talk about this infrastructure
started with
bill,
100
to
a
discuss why this funding is so
And
important. Today
even
is
more
significant of that.
And Daddy and I were
Officials say
equal
that
partners.
bridge was inspected last
Bye-bye.
September. A major
Talk to you
snowstorm
this
packing
weekend.
blizzard-like
Tom.
conditions forecast to hit
And the
coastal
rest of you,
areas of the
bye-bye.
east. It has people
Thanks for
stocking
listening.
up from
Watch.
Virginia on up to New England.
Definitely basics, milk and eggs and water.
And CBS News meteorologist David Parkinson says it'll be a rough one. Some places could get close to 2 feet of snow.
The wind gusts of 30, 40, 50, 60 miles an hour, the snowfall rates, the visibilities, all of those are causing problems. And then the other problem is it's bitterly cold. So you've got temperatures in the teens, but your feels like temperatures probably below zero.
And over the weekend, temps at freezing or below will invade much of the south. Russia's foreign minister